So now I'd like to introduce our two mediator experts, Eve Pienaar and Robin Somerville. Eve is one of the most sought-after mediators on CEDR's panel. Eve started her career at Clifford Chance and has subsequently held a number of in-house counsel roles at large organisations, including Warner Brothers, Royal Institute of Chartered Surveyors, the Royal Institute of British Architects. Eve is now a full-time mediator and has a busy practice across a range of commercial disputes, which includes some difficult multi-party projects which mediate over a longer period of time. Recent cases include division of assets between high net worth multi-generational family members and beneficiaries of multi-million pound trust funds. And she's worked with partners in professional services firms to negotiate terms of exit between partners and deep mergers of branches. Eve is highly regarded in the directory rankings and is identified by Lexology as a global thought leader in the mediation field. Eve is also a member of CEDR's faculty and provides training on mediation and conflict management services. Welcome, Eve.
Thank you, Richard.
Robin is a CEDR mediation panel member and a practicing barrister. Robin also sits as a judge on civil cases, often suggesting or even now making Churchill orders, ordering parties to attend mediation. As a mediator, Robin helps shareholders, directors, partners and businesses resolve their disputes and legal problems. His practice is centred around mediating, advising and acting as a mediation advocate in respect to shareholder and partnership disputes, encompassing a full range of businesses from startups to businesses worth hundreds of millions of pounds. Prior to qualifying as a mediator 15 years ago, Robin was involved in his family's third-generation business, which itself became involved in a shareholder and partnership dispute, which contributed to it entering administration. Robin has also successfully set up, grown and sold 3 tech startups of his own. This wider commercial experience enables Robin to pass on or draw on this experience for the commercial coalface lessons he has acquired in business to the benefit of his clients. So should we get into the subject of shareholder mediation and perhaps start with the legal context to shareholder disputes? Eve, can I ask this to you? What are the typical circumstances that you've seen that give rise to shareholder disputes?
Yes, thank you, Richard. So the circumstances which give rise to this kind of dispute are usually disputes over management control, exclusion by a minority of the shareholders from strategic decision-making. It's things like not distributing dividends or changing dividend policies without proper compliance, which causes an unfair prejudice to the minority shareholders. It's also diluting shares, inappropriately removing the audit of a company, for example, misvaluing classes of shares, prioritising a director's personal interests over the company's interests. That's a very frequent one. We get a lot of cases where directors are accused of inappropriately dealing with company assets and funneling away assets of the company for family members and the like, or withholding information, withholding accounts and that sort of thing. What I would say is shareholders usually begin their relationship with enthusiasm and a joint belief that it's going to be a successful venture, and they often don't consider what might happen when things don't go so right. So it can be very emotional. It can be very high party and complex set of circumstances. So really uniquely well suited to mediation.
Thanks, Eve. Robert, can I pass that one over to you?
I think Eve's done a really good job of summing up nearly all of those circumstances that typically give rise to shareholder disputes. I might add deadlock to that list. So often you'll find two 50-50 shareholders, and basically they've just fallen out, and because of the 50-50 nature of being a shareholder and perhaps a director as well, decisions just can't get made. So it descends into disputes. But other than that, I think Eve's covered everything.
Thanks, Robin. So where a shareholder dispute does arise, what are the typical legal claims that are available to shareholders?
So the classic one is an unfair prejudice petition brought under Section 994 of the Companies Act. There's also derivative claims when one director is alleged to have done something wrong effectively, and that needs permission of the court to bring a claim in the name of the company against that individual, typically by somebody who doesn't have sufficient control of the company themselves to initiate proceedings. Then more perhaps draconian is just and equitable winding up, Section 112, subsection 1G of the Insolvency Act, or perhaps a breach of a shareholders agreement or some other form of contract. So typically they'll form the bases of pretty much all shareholder disputes I can think of.
Thanks, Robin. Eve, is there anything that you would add to that list?
No, I think that's a very comprehensive list. I would just emphasise, though, that to bring a petition of this nature, you've got to show that there's been prejudice and also that it's been unfair. So they're not easy cases to bring, and therefore the evidence side of things can be quite complicated, and yeah, a lot of murky assumptions can be made, causing people to try to bring these cases when they don't actually have the right foundations to do so.
Thanks, Eve. And so where a litigant is able to establish unfair prejudice, or what are the remedies that the court will usually order if they find in favour of the complainant? Eve, can I send that one to you?
Yeah, sure, absolutely. So if unfair prejudice is proved, the court has a very wide discretion to make any order it considers fit under Section 996 of the Companies Act. Normally, it could often result in the buyout of a minority shareholder and order for account, but it could also include an order regulating the management of the company. Often, however, the relationships between the shareholders have deteriorated so far that that's probably not going to be practicable. The petition could seek for the dismissal of a director through or a derivative action, as Robin mentioned. And where the directors have caused assets to be dissipated, there may be some request to have the directors make good to the company. So the courts can, of course, order the just and equitable winding up of the company, and where there's been changes, say, to dividend policies, they can ask to reopen that. So I would say, in terms of examples, one case that I can think of where the minority shareholders were based in Poland and brought an action in the UK, there was a lot of evidence that came up at the mediation itself, the first mediation, which caused the majority shareholders to feel a bit more concerned than they had originally. And that was a case where we had a second mediation with just the principals a couple of weeks later. And that enabled them to look at wider types of outcome than a court would strictly have been required to find.
Thanks, Eve. Robin, do you have any further thoughts on the remedies that court will?
No, I think Eve again's done it, summarised everything properly. By far, the most common in my experience is where the court is effectively orders the majority to buy out the minority shareholder. That's, in my experience, nearly always the outcome. Sometimes, if it's not a trading company, like if it's a property investment company or something like that, the court might be more willing to have a look at a just and equitable winding up or something like that. But the court's very slow to step in and to effectively bring a successful, whatever degree that is, trading company to an end, putting all those people out of jobs and so on. So nearly always it's the majority nearly always buys out the minority.
Thanks, Robin. And these, I mean, the removal of directors or the buyouts and just equitable winding up, these are all quite draconian or severe remedies. Eve, do you have any sort of thoughts on how these outcomes can affect a company?
Well, I mean, it clearly affects the company quite considerably, especially if there's an order for winding up required. That's the end of the company, effectively. But I think in terms of goodwill and reputation, it can be very damaging. And also, by now, relationships have deteriorated significantly. So that can affect, the wider ecosystem around the company, from staff morale to supply chains and clients and clientele and the strategy of the company. So yeah, I would say they can cause a lot of havoc, a lot of damage to a company.
So the court actions and the outcomes, even if parties are successful, can be very disruptive and harmful to the operation and the ongoing business. So now we're here to talk about the mediation of shareholder disputes, and aside from the well-known advantages of mediation in terms of costs and the speed of the outcome, Robin, can I ask you, why do you consider or mediation is uniquely well placed to help shareholders in dispute?
Sure, I think speed of resolution is a particularly strong opportunity for mediation. These kind of shareholder disputes, typically the company's in some form of governance crisis, the directors have fallen out, decision making is not being made properly or at all. Sometimes, or perhaps even often, the company's in some form of financial distress, which might be at the root of what the dispute in the first place. And therefore, all of those features make it really urgent that the dispute gets resolved. Leaving it for 2 years or 3 years for a court case and for the unfair prejudice petition to make its way through the company's courts, that's far too long a process for most of these kind of businesses to survive these kind of disputes. The impacts on the company, on its sales, on its decision making, directors that are far too focused on the dispute and not focused enough on bringing in sales or getting widgets manufactured, completely distracted. Very often, as Eve said, these are personal relationships. Often people go into business together because of some form of either family business or friendship basis or something along, or even just a trust between two business people. And once those get ruined, then there's a possibility that again, that's going to have a significant impact. And reputation of the company, if it's often going to get out one way or another, that there's some form of a dispute. So mediation means you can solve all of those kind of things quickly. And in theory, we could talk about having one tomorrow. If CEDR's got that panel available, so if 2 shareholders wanted to arrange something in theory tomorrow, and in practice it's not really that quick, but in theory it is. But unless you're seeking an emergency injunction at the High Court or something, you're never going to get the wheels of justice to turn that quickly. So speed is a really big thing. I think the next big thing is creative outcomes. So a court's always going to be backwards facing or rearwards looking and think, who did something wrong and how should we put it right? It's black and white law, of course, is going to be followed, retrospectively focused. Whereas these kind of situations don't really need that as a solution, if we're honest. What it needs is creative outcomes. Can we do a demerger? Can one person buy somebody out? If so, how's that going to get funded? Any sort of, or could this person get to run this part of the business? You could split it into operational parts, or strict delineation of roles and responsibilities going forwards. All these kind of creative outcomes can be organised at mediation, whereas there's no chance of that happening at court. Of course, litigation is always expensive, but these kind of claims can be eye-wateringly expensive. Rarely are you going to get a matter like this all the way to trial if it's a contested trial, and these things are normally split between liability and then remedy. I'm not exaggerating when we're talking 300,000, 400,000, 500,000 each to run and then defend a claim like this. I was involved in one where one side, and it was only a 3-brother family business in respect of garages, and one party spent £1 million and the other party spent £600,000. So these kind of amounts of money are disproportionate to the issues, and the reason they're expensive is often these, as Eve set out, the businesses were founded on trust and friendly. Everyone was pulling in the same direction at the outset. Nobody made a record. Governance wasn't followed. One party said this to this in a pub over dinner one evening. That's then asserted to be a contractual relationship. These things often span years and years of complaints and lack of documentary evidence. So often you'll get a trial that's got thousands and thousands of pages of disclosure of WhatsApps and diary entries and all the rest of it. So disclosure is high. And then the trial itself could well take 5-10 days easily at the court. So we're very, very expensive. And the kind of sharks that fish in this sea tend to be the people that are looking to, be remunerated particularly well from a lawyer perspective. So you've got long, complicated litigation with lawyers who are at the top echelons of what they're being paid. So, and again, if you can cut all of that out, even before any pleadings or anything, you've just got two business people that can resolve this quickly at mediation, all of that complexity disappears.
Thanks, Robin. There's lots in there in terms of so the cost and time benefits, and so the cost you talked about, that's just the out-of-pocket cost of the lawyers and the time that the business management have to use being involved in litigation detracts from their concentration on the business. Eve, did you have anything to add on your thoughts on why mediation is particularly good in the context of shareholder disputes?
No, I agree with everything Robin said. Absolutely. I mean, these are complicated sets of litigation. Very often there's a number of different types of litigation afoot. And yeah, the evidence is really voluminous. And if it's e-disclosure, then, it's impenetrable. What I would say, and funnily enough, Robin, I worked on a three-brother shareholder dispute not long ago. They were in the scaffolding business, which is famously lucrative, by the way, but it's also quite shady. And one of the things which mediation helps with is private, it's confidential. And in this case, one brother had been sort of completely pushed out of the business by the other two, and frankly, the evidence that was coming out was so damning on both sides, that had HMRC been brought in, it just was a really big mess. So I think the opportunity to retain control over the dispute, the ability of the mediator to keep the parties apart when they no longer can speak to one another, let alone be in the same room, is another really unique benefit of mediation, I think, because we can absorb all of that emotion and anger, and we can focus them on forward thinking and practical carving up of the assets, when pension pots are mingled and assets are mingled, and there can be a constructive, creative way through it. So yeah, absolutely think mediation is a very useful tool in this field.
Thanks, Eve. You touched on some sort of third parties that can potentially be involved in mediation of shareholder disputes. Is there a wider group of stakeholders for whom mediation can be helpful in connection with shareholder disputes?
Yes, absolutely. I mean, certainly Robin hinted at the lawyers who have an active interest in this area, of course. But yes, there's of course all the wider relationships linked to the company and to the individuals concerned. So I mean, you'll often have the creditors are potentially would be interested, but you'd also have, I've often seen cases where the insolvency practitioner is bringing the claim on behalf of the company and roping back in, the shareholders and the directors. But in terms of wider stakeholders, well, obviously the staff and the family. When these are small family, a lot of family businesses are created as partnerships or limited liability companies for obvious reasons, so that they can protect their own house, or whatever, and then these issues arise. So it can be the insurers, the insolvency practitioners, it can be HMRC, the staff. That there's a wider whole ecosystem, as I mentioned, of parties who are interested.
Thanks, Eve. Robin, do you have any further thoughts on that? You mentioned considerations in relation to HMRC.
Yeah, there's a new pilot just about to start. It's in October, starting in the commercial court, where all of the pleadings, all of the skeleton arguments, all of the witness statements all of the key documents that are required to understand the case will be published by the court in the public domain. So those documents that you upload onto CE file and for the courts to use and for the other parties to use. All of those are going to be publicly available. I did provide a little link that I think might just be popping up into the chat facility there with a little Law Gazette article all about that, because I only found out about it relatively recently, and I thought that was a real motivator. And I remember being in court with a shareholder dispute, and HMRC joined via video conferencing, and they sat silently in the case, listening to everything that was going on. So Eve's example there of a scaffolding company, these companies are especially family businesses, but not limited to family businesses. People have had a company car and not declared it. They've got the company's paying for somebody's house. They've used building materials paid for by the company to do up their buy-to-let portfolios. So all of this, sometimes these kind of fines and penalties that HMRC may impose may even outweigh the value of these people's shares. So this is that as a third party, that's quite a scary prospect for people, even if they won't admit it up front. That back in the back of their minds, they're going to think, what did I put through the company that really, I shouldn't have done?
So yeah, a strong benefit of the confidentiality of the mediation agreement on umbrella in relation to stakeholders. We talked about the usual outcome, which is a clean break for shareholder disputes. Robin, can I ask you what considerations in the context of mediation do you need to achieve agreement on a clean break?
So the key information that parties should bring to mediation, unfortunately, it's not often enough, but they should bring to mediation, is some form of valuation that they've gone and had done. Each party could do their own, or there could be a joint valuation expert, because that's going to be, given that's what's going to be the normal remedy that a court orders, the value of the company is really important, because it means that's likely what the company is going to say, the court's going to say is that one person should buy the other person out. So if you come to mediation with no knowledge of what the valuation of the company is, then it's difficult to do an efficient, effective negotiation on the day. And I see this quite often when I'm mediating these disputes, is that there'll be an hour or two wasted on arguing about legal things and about evidential points. And then parties will start around lunchtime thinking about solutions, and maybe we could buy them out, or they could buy us out. And then they waste another hour or two because they hadn't thought about these things in advance, which they should. Whereas if they prepared properly, they would have said, okay, well, if they want to buy us out, here's a valuation, or we think the company's worth that, even if they don't want to actually share the valuation. But it gives them a good basis for them to at least make an offer or consider a counter offer that's being made. So I think it's really important that people try and do that preparation in advance of mediation so that they come prepared, because mediation is such a golden opportunity for them to resolve this. And if they're wasting significant parts of the day because they're underprepared, then the likelihood is that they're not going to be able to come to an agreement, or if they are, everyone's in a flap and they're not thinking things in a cool, collected way. They're just responding, and all of this information is kind of new, overwhelming information about valuations they hadn't really had time to think about.
Excellent, thanks, Robin. Eve, can I ask you the same question? What considerations in relation to achieving a clean break when people do to?
Yeah, I mean, I completely echo what you're saying, Robin. I mean, the importance of preparation in these cases is just fundamental. It's an investment. And I think it's the mediator's role, when you get the bundle, to interrogate it carefully and make sure that it's got the right information. if there isn't a valuation, or there are two very different valuations, you need to think about that ahead of time. Robin's quite right. That's not helpful at the mediation, where there's going to be a lot of issues to get through typically. And also, you want to give the other side time to interrogate the data that you're giving them. Often it's very voluminous. It'll be reams of bank statements, and it'll be, dividend example, the other side needs to have done the preparation work and interrogated all of this and analysed it, then speak to the mediator in the pre-mediation call, so that we narrow the issues if we've got a standing chance of actually making good progress on the day. So the counter to that is give a party the opportunity to look at what is being alleged that they did wrong, so that they have time to collate their own case and bring that to the fore. And hopefully there is sometimes parties do meet in joint session, and they can be very productive, because a lot of assumptions are being made on all sides, and there's points of clarification which can be helpful to get out of the way. I would also say that anticipating what documentation is going to be necessary on the day. I know we're going to come back to this point, I think, Richard, a little later, but where the mediator can encourage the lawyers involved, not just to bring a draft settlement agreement, but just to think about the other things that might be required on the day, even the format of a heads of terms. I mean, but come as prepared as possible, because it's emotion laden, and it's evidence rich, and it's usually complex with often multi-parties. So the more everything can be set up for success ahead of time, the better the chance of reaching a full settlement.
Richard, there was one more thing I forgot to mention in terms of preparation, and that's getting tax advice. Because if one party is going to buy another party out, then the person who's selling their shares, if they're not careful, may end up with a very, very substantial smaller pot if they haven't planned it properly. And the buyer may want to think about the manner in which they buy the shares. Should it be a company share buyback, or should somebody buy them shares directly? So, unless you've got a lawyer who's also a tax specialist, they are maybe not the best person to give that advice. It's something I always try to make sure I don't get involved in giving tax advice at all. So I'd always want clients to make sure that they've done that in advance, or at the very least they've got a tax advisor available to them during a mediation to ask those kind of questions, but preferably in advance.
Thanks, Harry. So a huge amount that people can do in advance in terms of preparing valuations, exchanging and agreeing basis for valuations, and exchanging the underlying information in order to lay the ground for a clean break, if that is the outcome that they reach. Clean break is the usual outcome, but can I ask you, have you got any experience of mediation offering to resolve issues between shareholder groups?
Well, I think, as Robin said right at the beginning of this session, quite often, if not in many of the cases, that it results in the minority shareholders being bought out. But by analogy with shareholder disputes, I do see mediation helping to resolve issues between parties who are sort of tied together in governance terms. So whether it's partnership, partnerships where the partners have fallen out, or I use mediation process and principles, for example, at board level with companies where the board is deadlocked. So one example I wanted to mention on this call was maybe rather UK typical, but a board of governors of a very well-known public school for girls in this country, where the board of governors, you couldn't remove any of the governors because they were there due to the royal charter that this school was organised under. And for non-UK attendees, you have to go to the Privy Council, which is basically a royal special court in this country, to change a royal charter. So that's very difficult to do, and that meant it was in complete deadlock, because you had a small cabal of governors who had decided that over their dead body would the school ever be different to what it was like when they went there many decades ago. And the whole idea was, the senior management wanted to bring this to the 21st century and have boys attend sixth form because they were losing a lot of market share. And it was very, very destructive, and also very destructive, frankly, to the school and therefore the girls and the wider stakeholder groups. And we used a mediation facilitation process over a period of weeks to engage with everybody, and that culminated in a mediation day with everybody around the table, very structured to avoid those people who tended to disrupt. And they found a way to agree a process whereby everybody felt heard, but there was a mechanism to break through the deadlock. And really, I really attribute that to the mediation principles. I don't know that they would have got there without, and certainly there'd been protracted litigation, there'd been defamation proceedings costing fortunes between the individual members. Now, these governors are volunteers, they're not paid for their time. So it was a good example of, mediation really bringing a successful outcome where people are, engaged in a common venture and have completely fallen out.
Thanks, Eve. And we certainly do see mediation and sort of facilitation projects used to resolve differences between boards, shareholders, and so on, as well as mediating when they need or that they have reached the point where they're going to go separate ways. Robin, can I ask you, have you got any happy stories of mediation restoring peace and harmony in shareholder disputes?
I don't have many of those kind of stories, I'm afraid, for you, Richard. Normally, by the time I've got involved, we're kind of beyond that. If parties were enlightened and sensible, I think there is definitely scope for this. Maybe the use of a mediator very early. So when people are unhappy with what's going on, they try hard to, in an enlightened way, resolve their unhappiness in a positive way. But often by the time, either a barrister or a formal mediator is appointed once there's a shareholder dispute, people have, like Eve suggested, they've made allegations of breach of trust and you've stolen this and you've had this out of the company and I haven't and I've been excluded. And it's really difficult to repair those kind of trust issues. Sometimes it can be usefully used for like an interim period, so that somebody has to run the company for 3 months or for 6 months while an asset's sold or moved or something. But Eve's obviously got a better feel for these kind of boardroom disputes before they descend into disputes. My experience tends to be more, we're talking about a commercial divorce, and it's about how to do it in a more effectively and efficiently.
Thanks, Robin. But often we talked about the shareholder disputes involving majorities and minorities, and in terms of this potential inequality of arms, Eve, can I ask you what are the potential issues that imbalances of power that you see in shareholders disputes can cause for mediation?
I mean, it's the nature of the game, isn't it, that the minority are in a position of less power, assuming the majority of the shareholders are a block or unit, if you want, because that's not always the case, but it's generally the case, even if it's just the financier behind it. I think one of the things that we can help the minority shareholder, obtain in coming to the table is to have legal advice. It's really unhelpful when you get a minority shareholder who is not benefiting from legal advice, because of course, as mediators, we can't give legal advice. So that's the first thing to try to put in place ahead of time to slightly correct that imbalance. But also it's about the information that's made available to the minority shareholders. So typically the majority may have frozen out that minority shareholder from information. You often see that in family businesses, for example, which are set up as limited liability companies, and individuals have shareholdings, but they may not have access to the account, and they may not have seen management accounts for years. So they're very, they're at a disadvantage in terms of understanding how to value the company for the purposes of a buyout, understanding, how some sort of minority discount should be applied. So going back to the key documents, the Articles of Association, any shareholders agreement, seeing whether there's any help in, anything in those documents which would enable them to have a contractual right to information might be a starting point. But I would emphasize the need to have them represented if that's at all possible. Of course, that we can't force that, and sometimes they don't have the means to do it.
Thanks, Steve. Can I ask the same thing to you, Robin, around inequality of arms and the issues that cause? Is there anything that the mediator can do to assist the legal advisors or the minority groups to ensure they're not disadvantaged?
It's tricky, isn't it? Because as soon as somebody's got more than 50%, the inequality of arms is really stark. That they can basically do what they want. They could remove another person as a director. They can push through changes, perhaps to the articles, depending on how they're written. And like I said, bearing in mind the costs that we're talking about in terms of legal costs, if a minority shareholder's got, even if they've got 2 or 3, 400, 500,000 pounds worth of shares, if they're going to have to invest £500,000 to argue over 2 or 300,000 pounds worth of shares, then you suddenly start thinking, am I equally armed here? Have I got a realistic threat of bringing any litigation? Because if they don't have a realistic threat of bringing litigation, then they're in a sticky situation where the balance of power clearly lies with the majority that can effectively push the shareholder around. So it's a very tricky situation in these minority shareholder disputes. The equality of power is can be a very, very sticky situation for them.
Thanks, Robin. You've emphasised the importance of getting legal advice and doing some of the preparation that we've talked about in terms of putting the minorities in the best position they can be at mediation. So if we talk about preparation, Robin, can I ask you what is typically involved in the preparation process for a mediation of a shareholder dispute?
So we've already talked about valuations. I think we've probably covered that already, but that's really important, and it typically involves just appointing an accountant. Like I said, either to fight your corner and effectively argue the value of the shares up or down, depending on which side of the table you're on. And then we need to think about who needs to be at the mediation. So is it just shareholders? Is it advisors? Do the company auditors need to be involved at all? So you need to prepare by thinking about who should be there. And then we often third parties' involvement is required. So let's take the example of a business that owns a warehouse or something along those lines, and there might be a bank who's been providing finance to provide that warehouse, to finance the warehouse. It may be that there are various banking covenants that are in place, so the directors can't change, or the shareholders can't materially change, or a director who's stood as personal guarantor for this loan, and that the bank still requires them to give that security. Sometimes it's in a regulated environment. So typically, if we're talking about maybe like regulated professionals like doctors or accountants, who if they're incorporated, regulators might need to be involved. Similar with landlords, if instead of buying that factory they've leased it, then the landlord's the tenancy might be in both their names, or they need the landlord's permission to shift the ownership from one to another or something. And there might be third-party investors as well. You often find that there are people lurking in the shadows that are either officially have lent the company money or have, even though they've got minority shareholding, they've got a say in, they've got the other directors in their pocket somehow to get them to do what they want. I often get shareholder disputes where somebody started a business, then they took third party investment from like an equity house or something along those lines, and then effectively the investment house or the private equity fund lose faith in the managing director, the old founder, because maybe sales are slipping or profits aren't up what they were. They lose faith in them, and then they force the old founder out. So that's quite a common shareholder dispute. So family businesses are one, founder investor kind of relationships, they're often another one. And effectively, if they've got a large loan, then if a creditor was to recall, and their contracts are so well written, these private equity companies, that they could pull, they can on demand, they can withdraw funding. Well, that brings the whole house of cards down. So effectively, that old founder's got no real power, even though their title is CEO and they're a director, they've got realistically no power. So all of these things need to be thought about in advance, so that when you're preparing for mediation, you're not surprised by these issues on the day, and that you've thought about these things and prepared for them.
Thanks, Robin. There's a huge array of different considerations for preparation, depending on the whole matrix of relationships of the company. Eve, did you have anything that you wanted to add to preparation generally for mediation of a shareholder dispute?
No, not really, other than to say it's surprising how often the shareholders want to hold the mediation without having done their due diligence and realise that they've given various covenants to the bank or other financial or other institutions, or sometimes key suppliers, which are going to be affected by this, and they would need to get certain consents in place, otherwise their hands are tied.
Thanks. One thing we haven't mentioned is company customers. I'm not sure if they have any particular role in it, but I guess their ongoing business maybe and securing that and confidence they're going to carry on with whatever is remaining in terms of leadership could be an important factor as well. There's a lot of preparation that goes into this mediation of a shareholder dispute, clearly. Do shareholders and their advisors generally, do these cases settle on a day, or do you find yourself negotiating over a longer time frame? Eve, can I ask that one to you?
I mean, anecdotally, most of the ones that I can think of have taken longer than a day. Despite preparing as best possible, there's inevitably more information that comes out on the day. There are also, interestingly, sort of different areas of concern that parties have, which can seem a bit strange to the mediator, but you just have to go with the flow. So they may not be very focused on where most of the value is. Maybe they're more focused on some of the key assets. So I've tended to find that very often these end up splitting between 2 days, with a bit of time in between just to process the further information that's come up, or to obtain the information that was missing. Hopefully not valuations, but that's not that's not a given. It could well be that they need to get further valuation because maybe more information has come to light which impacts the valuations that they brought to the table on the day. Generally, it's a balance, isn't it? You don't really want to break the momentum of the mediation on the day, but if the parties don't have the information they need to make the informed decisions, then it's better to build on the success of the first day's work and have another date in the diary. And sometimes I've done it with fewer people, and then you have a really focused meeting a week or two later where further information has been shared between the parties, and they know exactly what needs to be. They've narrowed the issues considerably, and that usually results in a settlement. I mean, I think, Robin, you were saying, I find the settlement rates in these cases is really quite high.
Yeah, I find that they're very high because the needs of the parties are to get this settled one way or another.
Yeah, absolutely.
Robin, just on some tips and thoughts for lawyers advising their clients, and is there anything that you can suggest is not a good idea for lawyers and their clients to do in the context of mediation of a shareholder dispute?
I would definitely recommend not to get bogged down in the legal aspects of the disputes. The unfair prejudice petition at the liability stage is just a route to getting the court to buy one party out or another. So why waste all of that time talking about who might win or who might not win? Because normally one party wants to leave and the other one wants them to leave. It's just a matter of price or something similar, akin to price. So to spend an hour or two arguing about whether something is likely to engage unfair prejudice or not, or some of these other legal aspects, or whether or not it's a quasi-partnership, and and looking at all the evidence, honestly, it doesn't really matter. and they all, by 2 or 3 o'clock in the afternoon, nobody cares about that conversation anymore. They've all moved on to how can we buy this person out, or how can that person sell their shares to us, or the other way around, or whatever it may be. And they move into problem solving mode, which is what mediation is all about and why it's so powerful.
Thanks, Robin. You both mentioned that these shareholder disputes happily have a high rate of success in your experience. They do settle regularly, and people find a way to agree their have a resolution between minorities and majorities. Eve, can I ask you what's the main points that you need to think about covering in a settlement agreement for a shareholder dispute?
I mean, these cases can be quite complex in terms of, there's a lot of strands typically to tie up. So realistically, it's more likely to be a heads of terms on the day than a fully fledged settlement agreement. But, if it's just an exit, then it can easily be a settlement agreement on the day. Obviously, I'm encouraging the parties to bring draft settlement agreements with having thought about the particular matrix of facts for this particular case, to bring that with you so that you don't, because it's very painful for all involved when it's late at night and you're waiting for hours for the other side to ping over their draft, which inevitably is absolutely covered in red pen. So that's helpful. I think also thinking through the compliance and the governance issues ahead of time. What I think we mentioned, didn't we, Robin, about sort of there might be lender consent required, landlord consent required. Just thinking of getting some of these things ready to line them up and record them in the settlement agreement so it can't be attacked down the line. Of course, one of our jobs as mediators is to make sure that the settlement agreement holds water and is not going to give rise to further disputes down the line. And obviously, there's a lot of issues around sort of non-competes, but I think, Robin, you're going to speak about that. But that's usually quite critical because obviously the parties have known intimately about the concerns of the business, and therefore thinking about how confidentiality extends is a relevant point as well.
Thanks very much, Eve. So there's a huge amount that people can actually do in terms of mapping out a settlement agreement or heads of terms, at least covering the key bits that need to go into it. You touched on restrictions on competition. Robin, do you have any thoughts about settlement generally, or potentially the sort of non-compete aspect?
Yeah, I mean, typically, if you think about a share purchase agreement, just as a corporate lawyer rather than a dispute lawyer, these kind of agreements run to 30, 40 pages and cover all sorts of eventualities. So that's why it's so hard, not impossible, but so hard to do it on the day. And yes, competition, non-solicitation, non-compete, all of those kind of clauses need to be thought about. Sometimes it's easy because someone doesn't, fed up with this sector, doesn't want to do this anymore, doesn't care about non-compete because they're not going to. Other times it's two business people that are, in a similar field, in a similar market. They might be young and they've got their careers ahead of them, and they can't deal with that would be a deal blocker if that meant that they have to, unless they're being bought out for so much money that they could put their feet up. But in my experience, business people don't normally put their feet up. They go and do something different. So it's whether they can stand the thought of being locked out of the market or, but use of confidential information, that does crop up regularly. So the buyer is typically going to say, well, we want all this confidential information protected. But if it's all in somebody's head rather than in spreadsheets, how does that realistically get protected against? So but this is why it's so hard to do these kind of deals all on the same night. But if you don't do it on the same night, there's a risk that someone thinks they go home to their family and friends and they make a drop a comment, and the person may think, oh, maybe I shouldn't have settled for that. Maybe I should rethink what I've agreed to. So,
Richard, if I can just add one thing which I've seen come up a couple of times, where the exiting shareholder has got information which is relevant to the other parties should a regulatory investigation take place, then I've sometimes seen the settlement agreement envisage that party A has no, can't disparage the business, therefore bring on, so I've seen cases where there's so much acrimony that they'll take their money on the day and then they'll try and backstab the majority shareholder. But B, will also assist, if required, because of course they sometimes have key knowledge which can be really important to help the company in an inquiry or an investigation. So I just thought I'd mention that, actually. It just came to mind. It's a slightly unusual provision, particular to this kind of dispute, I think.
Well, it's certainly an important one. You want to have all your resources if you're dealing with regulators and investigations. I was thinking as well, just practical things like returning mobile phones and laptops and things like that might have client lists and client numbers and so on that are alongside getting the advice on non-compete clauses, which I guess is something that people can start thinking about as part of the preparation process. We've got about 7 minutes left of the scheduled time. What I was going to ask is if I could perhaps have a final thoughts from both of you, and I'll ask Eve if you've got a sort of final thought first on shareholder dispute mediation.
Well, just you wouldn't be surprised that I'd very much advocate mediation for this kind of dispute, because often very painful situations, quite often in families, and it's causing a huge amount of disruption and pain and suffering, which actually mediation can quite quickly help the parties find creative outcomes and move forward in their lives.
Thanks very much, Eve. And Robin, final one from you.
Yeah, I think they're a golden opportunity for business people to move forward with their lives, just as Eve said. I think sort of if you say to someone, I'm a shareholder dispute lawyer, people start yawning and think these things are really boring and really dry. They're really not. They're really about humans. They're about people's livelihoods, people that have invested their entire professions for decades into this business. They feel it as part of themselves, or part of their identity is wrapped up in these things. A lot of evidence, a lot of water under the bridge, a lot of emotion. So they're really interesting cases to work on, and they're very rewarding to see that these people that are at war at the moment, by the end of the day, can move on with their lives and recover some stability and some planning opportunity to plan ahead. So really, really recommend mediation to try and help these disputes along.
Well, thank you, Robin. Thank you for that final thought, both of you. Thank you for all your thoughts through the session. I think we've got 5 minutes left, but maybe we can have a few questions. So I might just ask Anissa to come in. Anissa, do we have any questions that we can put forward to Eve and Robin?
Yes, we have a couple of questions. Can everybody hear me okay? Yes, okay. So the first question we have is, so in a lot of these shareholder and partnership disputes, there are two warring factions and a third party, the company, which often has a passive role, but may need to get involved if its interests are affected independently of the two factions. Does this give rise to unusual dynamics in a mediation? So that's the first question. I mean, there's a couple of others, but I might just give you a few minutes to answer that before I go on to the next.
Eve, did you want to have a shot first?
Sure. I mean, the company typically will, I mean, there would have to be a derivative action for the company to be involved in intimated litigation or litigation. But clearly it's about what the company's best interests were in the first place, and in terms of unfair prejudice, has somebody been prejudiced and dealt with unfairly in relation to that? So it goes back to the fact that these are multi-party cases. Very often it's not just a minority shareholder and a majority, and it's very often not that binary. There would be groups and factions within the shareholders, and there may be mediations within a mediation to handle that. But Robin, have your thoughts?
Yeah, I think if there's a deal to be done, then the two parties together will find a way to make sure that the company does whatever it needs to do to facilitate the deal. So I think by the time they've got a you were right in saying, the questioner was right in saying that broadly speaking, the company is normally passive, but by the time that there's an agreement, the settlement agreement typically the company will be brought in as a party in order to require it to pass, do whatever needs to be done from a corporate governance perspective and so on.
Thanks very much. Anisha, do we have perhaps we've got time for maybe 2 more?
Yes, so this is a question for Robin. So talking about a situation akin to a commercial divorce, the key issue I have struggled with is the inequality of arms, especially in situations of financial distress. How does one deal with a case in which one of the parties refuses to engage in ADR? In several cases, I have had a party refused ADR 2 to 3 times and then used a Part 36 offer to force a settlement without going through ADR. As a judge, what aspects of this refusal would you consider relevant when assessing costs?
So as a judge, so I don't sit in the company's court, so it'd have to be a relatively small matter that's in the county court for me to get involved with. But if I was to see something like this, I would certainly want to encourage. I would see immediately that there's an opportunity for mediation to be successful here. So I might want to try and make a Churchill order, or if I was an advocate, I might be asking the court to impose that order on the other intransigent party to try and force them to come to mediation. In terms of costs, if they've unreasonably refused to engage with mediation, then of course there's the sanction that they may not get their costs, or even if they lose, or even if they win, they may not get their costs, and they may have to pay the other party's costs. There's such a mountain of case law that's supportive now of mediation and carrying that the cost benefits. Just going back to the beginning of that whole process, though, I do often find that the other side's a bit intransigent. So I might be if I'm acting for one party and I'm inviting the other party to mediation, sometimes there's a resistance and sometimes there's an intransigence there. I think it depends a lot on how you ask them and how you invite them. If you beat them up with law and tell them what terrible people they are and how you're going to win and take loads of money off them, that's probably not the right approach. So over a number of years, I wouldn't say the word perfected, but I've worked on a style of invitation that effectively dangles a carrot in front of them, knowing what I think they might want. For example, they might want rid of my client or the other way around. So I kind of dangle it in front of them, not roll over and say, yeah, you can have what you want, but that there might be a possibility that if your client might be amenable to, commercially do a commercial deal, you may be able to get what you want. They'd kind of be crazy not to take up the offer. So I think it depends a lot on how you ask to get them involved. And then again, if they're still intransigent, then you can always go to court and make an application for a Churchill order to try and force them to do that.
Thanks, Robin. I think that was directed to you as sort of in your capacity as a judge. I'm not sure if you want to sit on the bench for a bit, Eve, or maybe Anissa, is there one that Eve can lead on to close out?
Yes, there's one more question. So in many jurisdictions, mediation has become a tricky word, suggesting like a lack of sophistication in dealing with complex commercial disputes. Do you find you need to educate parties as a first step, and how do you go about it?
Well, it's a good question. Different countries have a different sort of history of mediation progress. So might be, first of all, the mediation process itself might be slightly different. I know that in cases in France, preparation is it's a little bit different. There isn't so much work done in caucus than in joint sessions, that sort of thing. So it's about, from my perspective as mediator, I'm always happy to have a no obligation call or a Zoom call with the clients and or the lawyers, just to explain, how I approach a mediation, why I think it might be helpful, and let them, ask questions and test why they've got any reticence. And I do find that actually works quite well, because it just cuts through the assumptions that they've got about mediation not working, or not being for them, or their dispute not being suitable for it. And that doesn't cost them anything, and they get to learn a little bit, sometimes even about the other side. Because sometimes we have it as a joint call when we're process setting it up in terms of process design and deciding whether it's worth trying to engage in mediation with parties sometimes cross-border. So I hope that answers the question, but I think never hesitate to ask a mediator for you know, a no obligation short call, just to see whether the chemistry is there with the mediator, but also whether the approach is something that's likely to help your clients or the parties.
Yes, thanks, Eva. I mean, I'd like to echo that. I mean, mediation. We receive inquiries for all types of mediation, and often we offer people the opportunity to speak with a mediator to check that this is someone that you feel comfortable with and that you feel that you can work with, and having that the trust relationship with the mediator is very, very important, and it's part of the process, and it's something that you know, different approaches work in different situations. So it is something that I would always offer, and I'd say I'm to encourage people to take up more than they do. Right, I think we've got about 5 minutes over time. So I think we will call it there. And I would like to say thank you very much to Eve and to Robin for all their thoughts. I'd like to thank Anissa and Zara for their assistance with managing this and triaging the questions. I'd like to thank our audience for joining us. Thank you very much. I hope you have found that a useful and informative session. And with that, I think we'll close it out. So I'll say good evening and take care. Thank you. Goodbye.